This case is about the largest employer of pedophiles in the 300 plus year history of the state of Louisiana. When you hear the stories, it's hard not to be moved, and it's hard not to want to do something about it because that sense of injustice just takes over.
Thanks for tuning in to Keep It Legal, the show where we break down concepts, litigation, and current events with our legal experts. I'm your host, Mark Anik. Joining us today is Soren Gisleson of Herman Katz in New Orleans. Soren, thank you for taking time out of your day to chat with us.
Thank you very much.
I know that you and I want to talk about the cases that you and the firm have where you're representing individuals against the Catholic Church, the Archdiocese of New Orleans, individuals who have claims of sexual assault by priests and others associated with the church going back, to the 60s, 70s, 80s, what have you. Tell me a little bit, before we get to those cases, tell me something about you and your practice, because I'm going to assume that in your career in the law, you have not always worked on church sex abuse cases.
That's correct. I clerked for a federal judge in New Orleans upon graduation in around 1999. After that, I came straight to this law firm, Herman and Katz. I started out doing sort of general PI work, then multi-district litigation and class actions. And then Hurricane Katrina hit in 2005. After that, I was doing hundreds of first-party insurance cases against insurance companies and flood insurance companies. So basically, homeowners, wind, flood coverage, along with some commercial work in there as well. And then in 2010, there was the BP oil spill, just 5 years later, at which my partner, Steve Herman, was appointed as co-lead counsel on behalf of all plaintiffs for the putative classes of basically every resident and business in the states of Louisiana, Mississippi, Alabama, and the Gulf Coast counties of Texas and Florida. And so I did primarily BP litigation for the next, almost 9 years until it pretty much wrapped up. Had a couple phases of trials, hundreds of depositions, 72 million pages of documents exchanged, that kind of stuff. And then when that was just sort of dovetailing out and becoming less significant and less time consuming, co-counsel, a couple of local lawyers came to me and said, we keep getting approached by these adults who are abused by priests as children. It just started off as one or two, but apparently they're kind of talking to each other. And now we have like 5, 7, and 8. We talked about the statute of limitations problem, which we call prescription in Louisiana. And it sounded difficult in terms of the amount of time that went by, the memory issues. But there seemed to be one path that was a little bit unlikely, but the cause was righteous and it was the right thing to do. And the three of us are all products of Catholic high schools and Catholic grammar schools in this town. So we're all locals, all born and bred. So, when you hear the stories, it's hard not to be moved, and it's hard not to want to do something about it because that sense of injustice just takes over. And so you did. So we started filing 1, 2, then it became 20, 23 lawsuits in Orleans Parish in Louisiana, which is where the Archdiocese of New Orleans is kind of the seat of its diocese. And at that point, once we got to about 23 lawsuits, they filed for bankruptcy because of our lawsuits, because it was too much for them to deal with. They claimed it had to do with a host of different things, but at the end of the day, it was primarily the lawsuits, and it was an attempt by them to avoid litigation. They wanted to keep the documents hidden. They wanted to make sure the Archbishop did not get deposed. It was about secrecy and protecting their own. It wasn't about truth or purpose or principle.
You're going somewhere when you say it's about secrecy and protecting their own. I wanted to ask you something. You've got 23 cases that were on file before the bankruptcy, which I'm assuming stays those individual cases. But for a moment, play along with me if you would. If you were walking into court today and you were making an opening statement in one of those cases, you no doubt would look at the jurors and you would say, ladies and gentlemen, this is a case about. Fill in that blank for me. What is this case about fundamentally?
This case is about the largest employer of pedophiles in the 300 plus year history of the state of Louisiana. There has never been, nor hopefully will there ever be, a single employer responsible for or overseeing over 300 abusers, pedophiles, people who abuse children, people who abused adults who are at risk themselves. It is of a scope and a breadth I've never seen before. The state of Louisiana has probably never seen before. And the only way it was able to last the 70 plus years was because the Archdiocese of New Orleans and the various archbishops were able to conceal it. And by concealing it and hiding it and moving the priests around, they enabled the abuse to continue generation after generation after generation after generation, basically creating an entire subpopulation within the New Orleans metropolitan area of people who were traumatized and passed on their trauma unintentionally to who would become their spouse, their children, their parents, anyone around them. As you probably know, the rate of substance abuse, alcoholism, sex abuse, addictions skyrockets with these victims. And it doesn't really go away. It just metastasizes over time. And when it metastasizes like that and it's being buried and these people are existing in some kind of shame that they burden that's not their own, they unintentionally pass it on to other people. And it just spoils and soils almost everything.
Do you worry when you speak like that? It makes me wonder. I have confidence in your ability, right, and your co-counsel's ability to ultimately achieve justice for your clients. But does it worry you at all that even when you get to that point, you're dealing with people who are broken, permanently broken?
It's difficult. Justice is always relative. It's not winning a verdict and it's not getting a big monetary award. Sometimes justice can just be closure, and it can be a public declaration that you didn't do anything wrong. And that's a remarkable gift to be able to give someone, but it also takes time and you have to get there to that place. In order to get there to that particular place for those particular clients, it involves unsealing documents. It involves opening up the books. It involves disclosing what the Archdiocese knew and when it did and when it knew it and what it did with that information once it realized what it did. You know, there's one priest in particular who's kind of the poster child for the decades and generations of abuse, and that's his one. His name is Father Lawrence Hecker.
And this is the gentleman who was just indicted, correct?
Correct. And he, thanks to a deposition taken of Father Lawrence Hecker by my co-counsel Rick Trahan, and the remarkable thing is you can see that, and there's documents that prove this, that the last four archbishops knew about Lawrence Hecker's abuse. They knew what he did, and they didn't do anything, and they didn't report it. What they did instead was they moved him from parish to parish over 14 times within the Archdiocese of New Orleans, moved him over and over, city to city inside the parish, church to church, without any disclosure to anyone else that they knew what kind of monster he was. And to make matters worse, they made him the Archdiocese liaison to the Boy Scouts in the 1970s and 80s, so that he was the point person who would go on these trips with these little boys. And it's unknown the number of total victims that he has. We do know that he's probably got some of the most victims of anyone else, just because of the number of times he moved and the number of clients that we've represented who have made allegations against him. But he's a monster, has always been a monster. They always knew he was a monster, and they didn't treat him like a monster. They treated him like one of their own to protect and to secret away.
Does it strike you at all as amazing? You're talking about some of what the church did or allegedly did with him in the late 90s, happening after this period where there was plenty of publicity all over the country, in other dioceses, in other cities, that these same kinds of offenses had happened, and that the churches in those areas had reacted in the very same way, moving a priest from parish to parish to parish.
Sure, I can one up you there and say, since this bankruptcy has been filed, there have been priests within this bankruptcy accused of childhood sexual abuse and raping children. That's happened.
During the pendency of the bankruptcy?
Yes, during the pendency of the bankruptcy. And information and documents have come to light, which unfortunately I'm not allowed to share, that hasn't been put out in the public, but it's been known by the Archbishop, and he tried to cover it up, because that's all Archbishop Aymond tries to do, is cover up and silence and intimidate in secret. That's just what he does and how he operates.
You've mentioned a number of times that you're dealing with documents that are under seal. Presumably, when the other party goes into court and asks for a seal, they're trying to protect something or someone. And yet you're in court on behalf of plaintiffs saying, hey, I'm here. I want to move this case forward. I have nothing to hide. So who's being protected?
The secrecy of documents overwhelmingly protects the Archdiocese, the Archbishop, and the clergy who have been abusing children for generations in and around New Orleans. There are a number of ways to approach this issue, but there cannot be justice, closure, or even in a very pragmatic sense, the kind of assurance that this type of misconduct will not happen again in the future. The only way you can do that is when you bring in the entire community and say, this is the scope and the breadth of the abuse. This is how the institution of the Archdiocese enabled that abuse. And this is how we are going to prevent that from going forward in the future. Unless you have that kind of disclosure, you're not going to know what policies and practices to implement, what safeguards to insert. It can't be done. Otherwise, you're just guessing. And it's not justice. It's this sort of flaccid attempt at PR or PR control. And that's not what's in anyone's business. What should have happened, and it's sad that it didn't happen, and it hasn't happened in any of this litigation, but there should have been a judge at one point in our 23 cases or in the bankruptcy. The second they got this case, should have announced to everyone in the courtroom, we are a bunch of adults. We have responsibilities to our client, but we also have responsibility to the public at large. The very foundation of this case is criminal in nature, and it deals with the abuse of children. Even if it happened a long time ago, even if the particular abusing priest is dead, we need to get our hands around it. We need to identify documents that need to be part of a criminal referral and send those documents and that information to an authority, federal, state, or local, and let them make the decision about criminal conduct, whether somebody needs to be persecuted. But the nature and the substance of the case is so important, and the documents and the testimony are going to be so remarkable to figure out what happened so we don't do it again, that we've got to understand what is evidence of criminal behavior to be referred to authorities and what's not. And once we do that, as we can all come to this agreement, or the judge calls balls and strikes, I'll send it on and I'll make that criminal referral. But you can't. There hasn't been a single judge in any of these cases who looked at any of these documents that we've produced and have ever said, wow, this is evidence of criminal conduct. I need to send it criminally to someone. Fortunately, we had one judge who did unseal something, but it didn't have to deal with childhood sexual abuse. It had to do with a particular priest who was embezzling money from his congregation in the oldest African American church in the country. And so it's this just, I don't know if you call it a culture of cover up or apathy or just a misunderstanding of what the role is. But it seems to me that if you want to be a judge who protects the public, who understands the real cultural and safety concerns at issue here, and understanding that this is a civil case where only civil remedies are available, but the underlying conduct is criminal in nature, that when you see that disconnect, you got to put everybody on notice, and you got to include everybody's professional, legal, moral responsibility in achieving that. But so far, it's just bury, 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 bury. Keep it secret. Don't let the public know. They care more about newspaper articles coming out, they being the Archbishop and the Archdiocese, care more about newspaper articles coming out about their misconduct than they ever did about the children who are being raped by their employees. It's always been like that. And they see it as a problem that happened so long ago, it doesn't involve them. But you can do a throughput line of all the last 4 archbishops who all knew, using Lawrence Hecker as an example. We had to fight to get a deposition of Lawrence Hecker. We had to move a judge we had to move the bankruptcy judge to temporarily lift the stay so we could take his deposition before he died or became infirm. And then we did it. And some of the other documents were part of a criminal referral, first made to United States trustee. Then the trustee made it to the U.S. Attorney's Office, who then made it to the FBI. FBI, I assume, made it to the state police, who then made it, I guess, to the Orleans Parish District Attorney's Office. But come on, like 1, 2, 3, 4, 5 degrees removed before it gets to the entity that can actually do the prosecution. Lord knows how long that took, a year, maybe longer. That's not understanding your responsibility to the community for which you serve. As a judge, you're a taxpayer. I mean, your job, your responsibilities, whether you're on the federal bench or the state bench, you're a public servant. There's just no two ways about it. You're there to serve the public, not just within the confines of the judicial branch, but also when you see evidence of criminal misconduct. You don't have to call it a crime. It just has to be evidence of criminal misconduct. And it's at that point you need to make the referral. But these protective orders allow everything to be shielded, allow silence, allow it to be buried, allow people not to know what happened. And when nobody knows what happens, or nobody can speak, or the people who know what happened can't speak about it, then the abusing party, the party who facilitated or enabled the criminal misconduct, is allowed to do it again. Because what do they care?
You mentioned deposing Father Hecker, former Father Hecker. Were you in the room for the deposition?
It was during COVID, so it was all remote.
Okay. Were you on the Zoom?
I was on the Zoom.
What was that like, to hear that man be deposed and to testify about the things he had done?
To be clear, the deposition, I believe, is still under seal. So I can't talk about the contents of it, but I can tell you how I felt watching somebody like that answer those questions.
Okay.
And I can't tell you what his answers are, but it became clear to me that he bought into the Catholic Church's doctrination of priests are different and above the rest of us. And consequences for us, regular folk, are not the same for priests or clergy members, because they're special. They are the next closest thing to God walking on this earth. And as a result, a mistake by a pseudo God figure shouldn't be looked at the same way as a mistake by somebody like us. It's just different. And there was a certainty in his mindset the clarity with which he spoke was clear about it, not that it was okay for him, but it was within the realms of things that happened. I don't know if that makes sense.
No, I think it does. How do you think a jury would react to him?
Complete and utter disgust. The the way we talk about going to go buy breakfast at a local diner is the way and the tone he discussed abusing children. And just from a tonal position, that's just registers that kind of disconnect. People like to throw around words sociopathic and that kind of thing, where I've never done, I'm not a psychiatrist. I'm not going to toss around those words, but it was a disconnect between his tone and the content of what he was saying.
Let's talk bankruptcy, because you've mentioned it a number of times, and that's where you are right now with these cases. So I want to begin with a fundamental question. Is the Archdiocese of New Orleans bankrupt? Is it in danger of being bankrupt based on your litigation?
No, not even close. And this became evident in the very first filing of the bankruptcy papers in court. When it filed a Chapter 11 petition in federal bankruptcy court in New Orleans, it said essentially, as well as an affidavit from Father Patrick Carr, we're solvent. We have enough money to pay these obligations. We just kind of want to pay all these obligations at once. And so we filed bankruptcy. Everybody's going to get what those cryptic terms are. Everybody's going to get 100% of what they're owed. But of course, they're not saying what they think the abused victims are owed. It's what they think the claims were owed. The time they filed, there wasn't the new legislation that included a look back window. So they were looking at all these cases like they were, 5 cents on the dollar is all they were going to pay. And so they felt fine being able to put it all in a pot. In fact, and this has since been filed into the record, so I can disclose it, Archbishop Aymond wrote to the Vatican. And as he's wont to do, he lied to the Vatican about how much and what the value of these cases were. And so in the letter to the Vatican, he goes, look, this bankruptcy only going to cost us $7.5 million. That's all we're going to have to pay, and that's it. And so the $7.5 million number is important because if you file for bankruptcy that's $7.5 million or less in terms of financial liability, you don't need to ask the Vatican's permission. You just have to give the Vatican notice.
You don't need their permission to write a check for $7.5 million if you're the
Correct.
Archbishop.
Right. You just need the requirement is with canon law, you just have to give them notice. That's all. If it's 7.5 million or less. It's above 7.5 million, you got to get permission. And permission's a different animal altogether. Permission requires going through the hierarchy and whatever BS they go through at Vatican to approve somebody filing a bankruptcy based on the sheer number of lawsuits for your clergy abusing children in the community. So what's happened since then? We're talking 3.5 years ago, they filed bankruptcy. It was May 1st of 2020 when they filed their petition. So it's, they are just about north of $30 million that they've paid their lawyers and the professionals just to administer the bankruptcy. 30 million, 3.5 years it's taken. It's been over 2 years. The judge has had a pending motion to compel in front of her that she still hasn't resolved. The Archdiocese, at the time of filing, did disclose more financial information. So they, were able to disclose in a public filing that they had insured property in excess that they owned or responsible for in excess of $2 billion.
That's billion with a
billion
B.
with a B.
Thank you.
Yes.
Yeah.
And that is $2 billion of just the property. That does not include the land that property sits on. And we're talking the Archdiocese has got some of the best land in the city of New Orleans. The Archdiocese was here before it was a state. The Archdiocese has St. Louis Cathedral. obviously prime real estate. It's got the Ursuline Convent, a couple blocks from my house, prime real estate. They have multiple churches in every single neighborhood in this city. You can't walk more than a few blocks without running into a church. And that kind of income and wealth, and that's not even, it's not even including the personal property that they have. It's not including the hundreds of millions of dollars they had liquid in a particular account at the time that they filed for bankruptcy. But they spent the entire time for the last 3.5 years fighting the victims. They fought the victims when to include a deadline for which they had to file claims in the bankruptcy. They wouldn't even give the victims an extra month to file a claim when the victims asked for it. They said, no, we're not going to do it. You got to file it by the date we tell you to file it. And the judge agreed with them. The judge didn't agree with the victims. They went on and they fought about documents. They haven't agreed to a single document inside the bankruptcy that's not confidential. They've marked just about everything confidential in this bankruptcy. And they haven't agreed to a single document that shouldn't be confidential. There have been a series of articles in The Guardian from, I believe, August 8th. Let's see, I've got them in front of me. August 8th, 10th, and 12th of this year in The Guardian, which details the breadth and the scope of the abuse, details what's been going on in the bankruptcy, and gives a really good factual accounting of, the sheer volume of the number of clergy. For example, the Archdiocese only fesses up to about 70 or so of clergy who are abused, who are accused of being child abusers, whereas the articles do a good job of identifying over 300. That's a massive, massive number, and it's a massive discrepancy. And there are extremely simple reasons for that discrepancy based on self-reporting and other things that I can't get into because there's a protective order. It's not, the bankruptcy was designed as almost a furtherance of the Archdiocese efforts to secret and conceal. They knew that the Archbishop was not going to get deposed in the bankruptcy, so they filed bankruptcy. They knew, or they thought they knew, that none of their priests who were accused of abusing children were going to get deposed in the bankruptcy. We're able to depose one. That's something, I guess. They thought they were going to be able to keep every single one of those documents that show what they knew, when they knew it, and what they did with that information confidential, so the public would never, ever learn about it. And so far, 3.5 years later, they're right.
They've been successful.
Yeah, they're successful. They're willing to pay their lawyers and professionals over $30 million to keep those documents hidden.
A couple of times during this discussion, we've mentioned, Soren and I, some articles that have been published by The Guardian and a reporter there who's doing a very, very good job of covering this story. We're going to link those articles in our show notes. So if people listening are interested, you can go and just click on the link and read some of that coverage. Soren, is it I asked this because twice over the last couple of years, we've seen big corporations like Johnson & Johnson file for bankruptcy in order that they could stay ongoing litigation, in that case, tout cases, tens of thousands of tout claims. They file for bankruptcy, it stays the litigation, and those cases stop. As I look at this case, your case from the outside, I wonder, is it your opinion that the church is using the bankruptcy tactic for the same purpose?
Absolutely. It's a variation of the Texas two-step that you just alluded to out of Talc and J&J. J&J was a little bit different in where they carved off a piece of their company to really manage and mitigate their liability. Here, theoretically, everything's for sale. Everything's not, because it's a 501c3 company, you can't force it to liquidate its assets, which is insane to me, especially if the reason for the filing and the bankruptcy is criminal conduct. The underlying reason you're going into bankruptcy is criminal conduct. I don't care if you're a 501c3. I don't care if you're the Archbishop of New Orleans. You need to start selling off your damn assets, and you should be forced to do it. I'm being told the state of affairs of bankruptcy laws, you can't really do it, even if the underlying law is criminal, especially if there's not an entity or an authority out there currently prosecuting that entity for criminal misconduct. I mean, you would think if this was Walmart or Circle K and they engaged in this practice over 70 years in the state of Louisiana, if nothing else was going to happen, the Secretary of State would come a knocking and say, yeah, you guys can't practice business in the state anymore. You guys got to leave. We're going to kick you out. We're going to prosecute you, do everything else. Whereas here we're being told by the bankruptcy law is, no, not only are they going to still be allowed to practice their religion and engage in this misconduct in your neighborhood, in your community, we've been doing it for 70 years, we're going to shear the liability and we're not going to force them to sell anything. It's a bizarre state of affairs.
You mentioned the look-back statute. In any civil litigation, I don't need to tell you, you could educate me, you're the lawyer, there's a statute of limitations. In Louisiana, you have a different term for it.
Prescription.
Right. So your state legislature passed a bill that said for these cases, we're going to get rid of prescription for a period of time so that adults could come forward and file a case and say, this happened to me as a child. Tell me about the role that has played in this litigation and the difference it's made.
It's flipped it on its head. Credit to the state Louisiana legislature. They've never done this before. As far as I know, this is the first time they've ever done these two things, where they've come in and they included a look-back window on a tort claim for things that could have been prescribed or barred by the statute of limitations 5, 10, 15, 20 years ago or longer. And the second thing they did was they completely did without prescription and did without the statute of limitations. So now, as far as I know, for the first time in Louisiana, there's a tort that has no statute of limitations or prescription period for if you were sexually abused as a child. We're an incredibly conservative state, and that's a remarkable statement by the legislature. And it was unanimous in a very blue state, but with some red pockets. Democrats and Republicans got together, unanimously passed this statute and said, you've got until June 14th of 2024 to go ahead and file a lawsuit. If you think it was prescribed or couldn't have been brought in the past, you have this opportunity. That turned the entire bankruptcy on its head. So now the Archdiocese, after it filed for bankruptcy, thinking it was paying 5 cents on the dollar, now they're running around like, holy crap, now we got to pay 80 cents on the dollar, 90 cents on the dollar. This isn't a whatever bankruptcy. This is a XX $1 million bankruptcy. Could potentially be $1 billion, a B billion dollar bankruptcy. The Archdiocese of New Orleans has the money to cover it. And so it flipped, and it also created another problem with bankruptcy. By the time this statute passed for a look-back window, the deadline to file a claim in the bankruptcy had already passed. So now you've got these two conflicting events. You missed the deadline, theoretically, to file the claim in the bankruptcy because it's passed, but the Louisiana legislature unanimously gave you the right to file a lawsuit in state court up until June 14th. So what do you do with that contradiction? What do you do for all those people who are learning that, oh, wait, I still have time? Or all those people who maybe thought, I'm not going to file a claim in the bankruptcy. It's prescribed. It's barred by the statute of limitations. I'm going to get paid. I'm going to have to relive my trauma, get paid $5,000 for all the pain and suffering I've gone through my entire damn life, walk away and feel okay with that? Why would I put myself through that for $5,000? But now they're being told, wait a minute, it's not prescribed, but I missed the deadline. So what do I do with this? And the answer is we filed a motion to lift the stay, along with just about every other plaintiff lawyer group in the bankruptcy, explaining this very situation to the bankruptcy judge and saying, you got to give these guys an opportunity to file their lawsuit before June 14th.
To go back into state court and file a claim.
Correct.
Right.
Because it could lead to the most unfair, perverse situation where somebody either didn't file a claim in the bankruptcy or they did file a claim in the bankruptcy, before the look-back statute was passed. The look-back statute goes all the way to the date certain, which is June 14th. And then let's say June 30th, the district court dismisses the bankruptcy for whatever reason, which is a very real possibility. And then they go, oh, shit. And then they go try and they file their lawsuit in July of 2024. And then the defendant in that case files an exception of prescription or files a motion to dismiss because it's barred by the statute of limitations. And the poor plaintiff now goes, but the look back window. And then the judge goes, well, hey, buddy, that look back window closed 2 weeks ago. And you filed it 2 weeks late. And it doesn't apply to a claim filed in a bankruptcy. It only applies to a lawsuit filed in state court. And so hopefully we can get to a place where the debtor could understand it, which I doubt, or the judge will step up and rule accordingly.
So you and your co-counsel have filed a motion to lift that stay in state court so that additional victims could come forward and file.
We filed that stay before the bankruptcy judge.
Okay. And are we waiting now for the bankruptcy court to rule on that?
We had a hearing a couple weeks ago, and the judge rescheduled or continued the hearing for another date, December 21st, I believe.
Okay. I look at this, and I look at all of the hard work you and your co-counsel are doing, going on how many years now, Soren? When did you file the first? You told me that initially you filed up to 23 lawsuits. Do you know when you filed your first plaintiff's claim?
I think it was 2018, so I think it's more than 5 years ago.
Okay, so we're at 5+ years. You seem to me to be someone who does not give up easily / at all.
Oh, my co-counsel and I are in this till the end. We lay awake at night dreaming of a day we can get Archbishop Aymond in a deposition under oath on a video camera. We dream of the day that we can get a judge to look at each one of these documents concerning childhood sexual abuse and say, yeah, these aren't privileged. These don't have to deal with a trade secret, which is what privilege is, not privilege, but confidential. You know, that's what confidentiality is supposed to protect, business secrets and business this and maybe some other information, not criminal behavior perpetuated by a religious organization.
Have you run into any business secrets here that need protecting?
Nope. You would think that if your quote unquote business is ministering the word of God to your flock, that you would not want that to be confidential and that you would want to spread that as far and into the winds as you possibly could. And that any behavior supporting that mission would likewise not be confidential either. But according to the Archdiocese and the Archbishop, everything's privileged and confidential.
So what's the end game? What happens that finally gets you and your co-counsel into a room where you get to depose the Archbishop? What happens that gets all of this in front of a jury of 12 people someday who can vote yay or nay?
That could pretty much practically, or as a practical matter, only happen in state court, not in a federal bankruptcy. It's not structured that way. The only opportunity you can have is state court. So for that to happen, either the Archdiocese would need to dismiss the bankruptcy, which you can do in a dime. I'm not even sure it needs the bankruptcy court's quote unquote permission or leave of court. They can just do it under Chapter 11. Or we file motions to dismiss the bankruptcy for a host of reasons, especially the fact that they're just, however much money and assets they're having, they're bleeding out paying their lawyers. They clearly have no interest in paying the victims, and they just want to continue concealing documents and what they're trying to do is sweat out or weight the victims. And it's an insult to the victims. They don't bring them in. They don't try to understand what happened to them. They don't ask them questions. They don't read their proof of claims. The Archdiocese and the Archbishop don't do any of that stuff. So at the end of the day, it really is, do we file a motion to dismiss this bankruptcy? And I think the answer to that question is going to be made in January of next year.
You're getting to my next question. I appreciate you doing that. If you could look into your crystal ball for me, what happens in this case in 2024?
I think unless there is a serious paradigmatic shift in the way the archdiocese and its lawyers and the archbishop think, that all signs, 3.5 years, $30 million paying lawyers, bearing all the information, and basically employing bullying tactics against the survivors from the beginning. If I look as the past as prologue for the future, I think there's going to have to be a motion to dismiss filed, unless they change their tune. Which, like I said, there hasn't been a single comment. They just want to save their money. That's all they want, and their assets.
What do you say to your clients who are still waiting, not only 5 years later, they're waiting decades later for justice? What do you say to them?
There's some fascinating research out there that says the average age of a person who suffered childhood sexual abuse.
Is 52 that they come
Yeah,
forward.
yeah.
Yeah.
And it makes sense. You go through a journey during your abuse where you try to figure out what happened, why it happened, whose fault is it, and hopefully you get to a place, and not everyone does, where they can confide in someone else. And for whatever reason, that time seems to be their early 50s. And when you get to that place and you're at that level of maturity, what our clients are really looking for and what they express more than anything is a full airing of everything that happened. Who knew what, when, and what did they do with that information? That is the first thing to see and to look at and to do and to sort of synthesize that information. And look, there for decades, they intentionally did not document complaints of abuse, criticisms of abuse, phone calls, letters, whatever the main method for communicating abuse back then was. They intentionally did not memorialize it in writing and keep those documents for the very obvious reasons we can all imagine. So, because of that, it's even more important to develop an understanding of how they functioned. What did they do as a policy, practice, and procedure when they got these abuse claims? Who was talking to each other? Who had decisional authority when an abuse claim came in? And it went up to the chain. Was it the archbishop? Damn right, it's the archbishop. Only the archbishop can make that call. That's always been the case, and that's the case today. What did the archbishop do with that information? Well, I'm pretty sure there are documents that identify what they did with that information that maybe doesn't apply to one of our individual clients. But when they see it, they will go, happened to that guy. It was their policy, practice, and procedure forever. And I know that's what happened to me. And there's value in that.
Last question, maybe. As you watch how the church in New Orleans is approaching your case and these cases, does it make you wonder at all how safe kids are today? Because the church has been subject to this reporting across the country, across the world, right? And there have been all sorts of reforms and mandates in different dioceses that you have to have this training and you have to have, different certifications if you're going to be working with kids, et cetera. But when you watch what the church in New Orleans has done and how it has reacted to you and your clients, does that say anything in your mind about what it's doing proactively to make sure that this is not happening in 2023 and 2024?
Oh, absolutely. You're looking a lot of times, it's kind of weird to do it. You look at it in terms of risk. And where is that risk? Is it elevated? Is it middling? Is it a low risk? In what ways was that risk aggravated or mitigated? It's clear that there's so much more awareness today than there ever has been about clergy abuse, that people are more aware and they have a heightened awareness. They're looking out for it. They're more aware of the signs of what that could be. Maybe a different generation. If you saw a kid withdraw, you might think, oh, whatever's happening in school. But now you might ask some more pointed questions, and that's important. But when you drill down, I think it's easy to say, and it's fair to say, that there's still an elevated risk in this community to this misconduct because the Archdiocese and this Archbishop continues to insist on secrecy. And when you have secrecy, you are always allowing a problem to fester because it's not seeing daylight. It's not being addressed by disinterested outside parties. And it just festers and it metastasizes. And that's what secrecy does. It just allows problems to metastasize. And that's what they did for generations. And until they get over this secrecy issue that they have, it's going to continue to be an elevated risk of which it has no business being.
Soren, thanks again for joining us today. Again, that was Soren Gisleson of Herman Katz in New Orleans. You can visit hhklawfirm.com for more information about Soren and about the firm. Make sure to like us on Facebook, subscribe to us on YouTube, and tune in next time to Keep It Legal. I'm your host, Mark Anik. We'll see you then.